Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about protest. Cases that should have gone to the Supreme Court of Canada, but didn't. There were a lot of protests, if you recall, during the COVID-19 pandemic, and especially in times where there were significant restrictions in place. During one such protest, an individual was asked by police to leave the area, and rather than leave the area, he sat down and refused to move. Ultimately, he was charged with a number of criminal offenses, including obstruction and a few counts of mischief. The accused was convicted, and he argued that the mischief count was duplicative of the obstruction count, that what constituted the mischief also constituted the obstruction, and therefore the conviction should only stand with respect to one of them. This is known as the Kienapple principle in Canadian law, where you can't have more than one conviction flowing from a single act unless the elements of the offense are substantially different. And this has been a very vexing issue for courts of appeal across the country. The BC Court of Appeal did a very deep dive into this a couple years ago and then kind of reversed course a little bit later. And so courts of appeal are really struggling with, it seems, the application of the Kienapple principle to these cases. And that is so much more important when it comes to protest-related charges, because protest is a protected right under the Charter, your right to free expression, your right to association. Charges that stem from protest conduct should be viewed even more carefully in respect of whether there is essentially a double jeopardy that is happening when a person is convicted of multiple offenses arising from their protest conduct. This is important because it informs people who want to exercise their constitutional liberties in this country of what jeopardy they may actually be facing. And so long as the law is unclear, or the law is divided, or the law continues to be evolving in a way that provides uncertainty, people have uncertainty in when and how they can exercise their rights and what consequences they might face for certain types of breaches of the peace. Individuals should have the right to know, especially when it comes to something that touches so significantly on your right to exercise a charter-protected right. Unfortunately, the Supreme Court of Canada really failed to see the way that the conviction and the double conviction issue in this case intertwined with exercise of important constitutional rights, exercise of liberties in this country, and the way that these dovetail in a way that makes sense to give clear guidance. Hopefully the Supreme Court of Canada has another opportunity to consider this issue again soon and provide clear direction to the courts so that people can know how they can exercise their rights, how they can protest, and how they can make their voice heard in a lawful or partly lawful way. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Pool Creative for putting together these videos. Please like, subscribe, and share with your friends.